May I please, your lordship, for a listing of orders material in criminal petition, my lord, can it be in the new year, my lord?
Okay, orders.
God bless you, lord.
First week of January.
What interlocutory application?
We have challenged public order. Court had issued further proof. 2020 that continue. Therefore, better ask 12. For extent relief because 26 it was not extended.
Immediately on reopening.
Lordship, the matter.
Reopening.
Lordship, the trial court matter is fixed on 30th of December. Before the trial court, the next date is 30 December.
We'll not apply our mind today. We'll post it only. Okay, get it listed so that you can take an adjournment.
Lord.
May I please, your lordship, we have to mention one IA criminal for listing in the January, your lordship, 7th.
Yes, sir.
Lordship, I will mention item 22. Though it was fixed on by mentioning, my lords, my lord, what had happened, my lord, there's a flood of, my lord, the government matters today, my lord, due to vacation. A lot of matters have come. I could not devote my time to this, my lord.
Okay.
Can it be on 7th?
Okay. Under prayer of Mr. D. Gogol and counsel for the petitioner is the case on 22. Okay, 7.
Maybe, Lordship. Lordship will consider other side, Lordship. I beg to mention item number 14 and 15, Lordship.
14 and 15.
Mr. As the out of station, Lordship, matter may be adjourned for the day, Lordship.
14 and 15. Okay.
14 and 15.
On the prayer of Mr.
Ace Islam on behalf of S. Dash.
Okay. It's Islam Land Council on behalf of Mr. Miss S. Das Land Council for the petitioner in 14 and for the response number 2 in 15 has made a prayer for adjournment. You are for?
And for the petitioner.
Miss A. Begum, Land Additional Public Prosecutor for the respondent state is present. You are for? You were not there. Okay. It is submitted that consent has been taken from the Land Council for the other side to make the prayer. As sought for. After Bihu, please the cases on bench.
May it please, your lordship, I beg to mention item number 5. Yes,
Yes.
please pass over the matter for a day and fix it on first week of January.
On the prayer of Miss So-and-so. What is there? Okay, we'll motion matter. Okay, we'll pass the order as and when it is called, right? You wait there.
Daily list for motion, item 1.
May I please, your lordship?
Yes.
In this case, my lord, in a CRDV case, my lord, the learned trial court has rightly decided, your lordship, and directed the respondent number 2 to pay maintenance of rupees 15,000 to the petitioner and
No, first, it is a DV case.
my lords.
Aggrieved person, wife. Okay, what is the trial court order? Final
Page
order.
54, your lordship, operating part.
Operative part, page 54.
54, your lordship.
Prohibited from coming respondent direct pay per month to the aggrieved person as maintenance. Amount shall be payable from the date of filing. 15,000 granted.
My lord, against this order, your lordship, the respondent number 2 filed an appeal before the
Okay. Hmm.
appellate court, your lordship. And
Where is that order?
at page 57, your lord,
57.
my lord. And this appeal was filed after about 2 years from the date of passing the
What
order of the trial court.
delay was condoned?
delay was condoned, but only
I would opinion that the interest of the
and the matter was sent back for fresh trial, Your Lordship, and nothing has been stated regarding the maintenance, Your Lordship. And she is not getting any maintenance. The reason number 2 is a government employee, Your Lordship.
for some period, what is the date of the trial court order?
My lord, they had not stated anything regarding this.
9/10/2023. So, your husband is a government railway employee.
Railway employee.
And for what purpose he was earning zero salary?
For his physical ailments.
Hmm.
And
Medical ailment.
my lord, and the same was not brought to the notice before the learned trial court. Although several times opportunity was
judgment?
given to the petitioner, to the respondent number 2, Your Lord.
Yes.
My lord, I have annexed the order
Oh.
sheet, Your Lordship. On several occasions, he remained absent. On third
He
time,
filed a written statement.
my lord.
He filed written statement there.
Yes, Your Lordship.
Never came to know
written
the
statement
accident
at
as a
page-
result of his leg fracture.
Page 22 onwards. Written statement.
It is there, he stated so, but
My lord.
there was expertise, right?
My lord. Third time was expertise, my lord. One after another third. My lord, after expertise, he prayed, then vacated.
Now presently he is, how he is,
Presently, he is receiving gross salary of 43,465. He is well presently. He is performing his
failed
duty.
to appear.
The case of the
And after the trial court judgment, did he pay?
nothing was paid, Your Lordship.
Hmm?
No sort of maintenance has been. The case of the respondent number 2 is only he got salary, zero salary from July 22 till January 24. And this aspect was brought to the appellate court, Your Lordship,
Yes, Ms. Begum.
but
what
not
to
in
do?
trial.
This the notice must be because we'll have to hear them also.
But
So far as further proceeding is concerned, it should be whether it is reasonable or not,
Lordship,
just because once he defaulted,
Lordship,
it was ex parte. Now he is coming up with a plea that during that period, he was without salary.
Lordship.
That can be considered, but question is, if he is receiving some amount now, what is the
There
problem?
was mediation also.
Yes,
Lordship.
for that period may be relaxed.
Lordship,
If he is really without pay for this period, but so far as current salary, if he is having current salary now,
Then
full
what can
salary,
be? Lordship,
that can be relaxed also.
that can be.
So further proceeding before the trial court shall remain suspended.
Well,
Will not comment on the salary, let him come, thereafter we'll direct,
Lordship,
right? But no further evidence for him,
well,
right?
and presently,
And
current monthly maintenance may be provided. Current monthly.
no, this further proceeding is stayed.
Lordship.
Heard
Then
Mr. E. Hussain.
yeah,
Let him come, then he will come running.
Well,
Lordship,
E. Hussain,
A. Rahman.
A. Rahman, learned counsel for the petitioner. And Miss A. Begum, learned additional public prosecutor for the respondent number 1, State of Assam. Full stop. The petitioner as aggrieved person instituted proceedings under Section 12 of the Protection of Women from Domestic Violence Act 2005. deviate before the Court of Judicial Magistrate, First Class Dhubri Trial Court, seeking a number of reliefs under the DV Act. Post of the instituted proceeding in the form of CR within bracket D stroke V, page 45, number 221 stroke 2021. Post of. On receipt of notice, comma, the respondent, sole respondent herein, that is the respondent number 2 herein, entered appearance and submitted his written statement. Post of. However, on and from 19/9/2023, the respondent did not appear before the trial court, and as a result, comma, the proceedings, the case proceeded ex parte against him. Post of. The trial court, after hearing, after considering the evidence laid before it, passed a final order on 9/10/2023, directing inter alia, directing respondent and directing inter alia directing the respondent to pay an amount of rupees 15,000 per month to the agreed person as maintenance, and the amount shall be payable from the date of filing of the application. Post of. It was in 2025 only, comma, the respondent preferred an appeal, comma, criminal appeal case number 11 of 2025 before the Appellate Court of Additional Session Judge against the final order dated 19/9/2023. So before the Appellate Court, comma, the respondent as appellant advanced a plea that during the period from July 2022 till January 2024, comma, he did not receive any salary from his employer, comma, the railways, due to his medical ailment. Full stop. Para. The appellate court, holding a view that the said aspect was not considered by the trial court, has remanded the matter to the trial court, comma, by an order dated 5/12/2025, comma, for a fresh consideration from the evidence stage. Full stop. Para, issue notice returnable on so and so date. as Ms. Begum has appeared, accepted notice on behalf of the respondent number one state. Formal notice is not necessary, extra copy within 2 working days. The petitioner shall take steps for service of notice upon the respondent number two by speed post within 2 working days from today. Post of para. The respondent in CRB stroke V number 221 stroke 2022 submitted his written statement wherein he mentioned that he was on leave due to accident and at the relevant point of time, he was without pay. Post of. After the final order dated 9/10/2023, the respondent preferred an appeal only in the year 2025. Post of. The appellate court only for the reason that during the for the reason that during the period from July 2022 to January 2024, the respondent was receiving nil salary, remanded the matter for fresh consideration. Post of. Having regard to the reasonings, having regard to the manner in which the matter has been remanded back to the trial court for his consideration, this court is of the considered view that further proceeding, as directed by the appellate court in the order dated 5/12/2024, 5, before the trial court shall remain suspended till the returnable date,
6 February.
6 February.
Item 2,
Yeah, that's good. This revision petition for Zimma office matter 7.65 matter pistol matter. It was seized on matter.
Yes, madam, get a report from the
Madam,
IO.
Madam,
That
request
last
of-
order was of 21/11/2025, Lordship. In that regard, Lordship, the Jimma was rejected, Lordship, for further investigation.
Against that only,
Lordship, and again,
against that only he has come.
Lordship, for that, Lordship, I'll be.
Heard Mr. A. Khonikar, learned counsel for the petitioner, and Ms. A. Begum, learned additional public prosecutor for the respondent state. Post of. The petitioner has preferred this criminal revision petition against an order dated 21/11/2025, passed by the Court of Additional Chief Judicial Magistrate Hemaji, in petition number 312/2025, filed by the petitioner in connection with DR case number 404/2025, full stop, by the impugned order dated 21/11/2025, the petitioner's application for custody of a firearm VIZ 7.65 pistol has been rejected on the ground that the same would be required for the purpose of proper investigation. First of. issue notice returnable on your immediate piece of detail. Emma,
19.
as Miss Begum has appeared, accepted no. Formal notice no, sorry,
19
one
February.
extra copy. Miss Learned Additional Public Prosecutor shall obtain a report from the IO of, what is the case number?
Silapatra PS case number
Tilapothar Police Station, case number
176.
176/2025. As regards necessity of retaining the custody of the firearm in question, along with the justification to place the same on the next little listing.
Deep blue. Item number 3.
May I please, your lordship? Lordship, NI Act case, your lordship.
And a case, trial court. What is the trial court judgment?
Trial court operative,
You are Jamaluddin Ahmed.
lordship.
Okay, where is the trial court judgment?
It starts, lordship, from page 35, but operative
35.
portion starts
What is the check amount?
1,30,000, lordship,
1,30,000.
30,000.
Okay, where is the operative part?
Page 62, it starts from
62.
paragraph 49.
1 year, 2 lakh.
1 year,
2 lakh.
2 lakhs.
Then appeal preferred.
Appeal preferred,
Where is
lordship.
the appeal order?
Appeal order, page 72, operative, lordship. One year reduced to 30 days,
So very lenient.
lordship. But the petitioner, lordship,
Now it is case of 20%.
lordship,
Deposit.
yes, your lordship.
Heard Mr. A.R. Shum, Learned Counsel for the revision petitioner. Full stop. The present criminal revision petition is preferred against a judgment and order dated 15/5/2025, passed by the Court of Sessions Judge Sirang at Kajalgaon, within bracket Appellate Court, in criminal appeal case number 45 of 2025. Full stop. By the judgment and order dated 15/5/2025, the Appellate Court dismissed the appeal preferred by the revision petitioner herein as the appellant against partly allowed
Partly allowed.
the criminal appeal preferred by the revision petitioner as the appellant against a judgment and order dated 30/01/2025, passed by the Court of Additional Chief Judicial Magistrate Sirang Kajalgaon in NICR case number 15/2022. Full stop. The complaint in NICR case number 15/2022 was instituted by the respondent herein as the complainant against the owner of a check for an amount of rupees 1,30,000 issued by the accused therein, that is the petitioner herein, in favor of the respondent therein, that is the petitioner, complainant therein, that is the respondent herein, from an account maintained at Kaupati, Koupati branch, Udalguri of the State Bank of India. Post of para. The trial court had convicted the petitioner, accused for the offense under section 138 Negotiable Instrument Act and had convicted and had sentenced the accused, petitioner stroke accused, to undergo simple imprisonment for a period of 1 year and to pay a fine of rupees 2 lakh to the complainant. Full stop. While partly allowing the appeal, the appellate court has reduced the sentence of 1 year of imprisonment to 30 days while retaining the fine amount. Full stop. Aggrieved thereby, the petitioner accused has preferred the present revision petition. Full stop. Issue notice returnable on so and so date. Let LCS, TCS from the trial court and the appellate court be called for. The petitioners will take steps for service of notice upon the respondent by speed post with AD. Full stop. I heard Mr. A.R. Som, learned counsel for the applicant revision petitioner. The instant interlocutory application and this is equivalent to 389,
Lordship.
huh?
Lordship.
Section 438 Bharatiya Nagarik Suraksha Honida 2023, seeking suspension of execution of the sentence passed against the applicant as revision petitioner and for his release on bail. So stop. Para option next line to the applicant revision petition applicant as the revision petitioner has preferred the accompanying criminal revision petition number 535/2025 by Gini Milai Divo. Para issue notice, not issue notice, as the fine amount is of 2000, the fine amount imposed by the trial court and affirmed by the appellate court is rupees 2 lakh. Para, the applicant revision petitioner has not been able to, no, I have gone through the materials on record, including the judgment and order passed by the trial court as well as by the appellate court. Post of having gone through the same comma, this court has not found any reason, not to speak good and sufficient reason, comma, to waive or reduce the statutory deposit required as per the provisions of section 148
Lordship.
within bracket 1 of the Negotiable Instrument Act. First of para. It is therefore ordered that the suspension, the execution of the sentence passed against the applicant revision petitioner shall remain suspended, subject to deposit, shall remain suspended pending disposal of the accompanying criminal revision petition, comma, subject to deposit of 20% of the fine amount within a period of 60 days from today before the trial court. First off, it is further observed that the petitioner, applicant revision petitioner, is to be released on bail subject to furnishing a bail bond of rupees 10,000 with one surety of the like amount to the satisfaction of the trial court in the meantime. First off, it is also observed that in the event of failure on the part of the applicant revision petitioner to deposit the sum amount, the amount directed within a period of 60, within the prescribed period, the matter of continuation of the order regarding suspension would be reconsidered. Post of the applicant revision petitioner shall deposit, shall place a receipt regarding deposit of the amount after expiry of 60 days.
Oblige your lordship, a criminal appeal number 14 of 2025.
Okay, page to sile over. What is the page?
Lordship. It is.
Page 60.
it's titled-
Sile over 60. Criminal appeal case number 14 of
14 of-
2025.
Oblige your lordship.
Item 4.
Criminal petition.
Scan copy trial TCR. Received, no received, not received,
No,
not received.
Not received.
the NBW call.
Wait, you have to wait. 2015.
Yes, lordship. But concerning sir lordship, the amount received lordship.
That is why perhaps court
In
has.
the year 2025.
Let TCR be called RC Das. Will issue reminder. RC Das for the petitioner. A Begum. Learned. Additional public prosecutor for the respondent's state. So stop. By the previous order dated 8/12/2025, the trial court records were called for. Full stop. Para as per office notes dated.
Lordship, with due respect, lordship, the page number 38, lordship, there are considered 10 accused, lordship, 5 accused already enlarged on bail, lordship, page 38.
Trial court records of PRC case, PRC number
Yes, lord.
1582, 2022. Were called for.
The page, sorry for that, page 38, lord. So here in the 5 accused already enlarged on bail, lordship.
That is a defined issue. Court has a coordinate bench.
Lordship.
Having gone through the records, decided. So I am not deviating from that. Issue a reminder for the TCR. Release the case on.
19-1.
So, lordship, next date is the 8/1, lordship.
Can't help it.
19.
19.
Already you have fixed many matters in the first week. Not possible.
Yes, must suffice.
Item 5.
Yes, something was mentioned in
Lordship.
the morning. What was mentioned?
It was mentioned that after vacation, Lordship,
After vacation.
after vacation,
Scan copy of case diary not received.
not received.
The learned counsel for the petitioner and the learned additional public prosecutor for the respondent state is present, are present. Full stop. By the previous order dated 9/12/2025, the scanned copies of the concerned case diary were scanned copy was called for. Full stop. As per office note dated 17/12/2025, the case diary within brackets scan copy is not received. Post of issue a reminder. Please the case on same 19-1.
Item 6.
Is Sony. Imran's. Yes.
Hey, please, your lord. This is a criminal petition that impugn order is case number 38, my lord.
Case number
38, my lord.
30.
38.
38.
Oh, sorry, my lord, 37.
37 handwritten.
37, 38. Order of the PRC case number, my lord. Here, my lord, kindly see the second para, my lord.
Let me read.
According to the particulars of offense under section 506 of the IPC, read with section 34 of IPC have been read over and explained to the accused person to which they pleaded not guilty. My lord, here charge has been framed under section 506 and 34, my lord. My lord, here the complainant filed a complaint before the judicial magistrate, that is in page number 18, my lord.
Huh.
Yes, my lord. Kindly see page number 18, my lord. Complaint.
Page
Complaint.
number 18.
Yes, madam.
Yes.
My lord, here Dia Setri is the complainant, and my lord, accused are from the same family: Nitesh Soni, Dinesh Soni, Sanju Soni, Nishan Soni, Simran Soni. Here, my lord, accused number 1, 4 and 5 is the son and daughter of accused number 2 and 3, my lord. 2 and 3 is the husband and wife, my lord. My lord, here they filed a complaint before the magistrate, and on the basis of this complaint, my lord, FIR was lodged, that is in page number 26, my lord. Page number 26, my lord, FIR. And my lord, charge sheet is page number 28, my lord.
Fire 26.
Yes, my lord. And charge sheet is page number 28, my lord.
This complaint is the FIR?
Yes, complaint is FIR. After that, my lord, the police lodged this FIR, my lord. And on the basis of that, charge well plan, that is in page number 28.
Understood.
Charges are under section 294, 506 and 34. For all the accused.
When a complaint was lodged,
Complaint was lodged in, my lord.
Thousand 2024. What is
2nd
the
March
date?
2024, my lord.
2nd March.
Yes, my lord. There my case is that, my lord, there are, my lord, three charges, my lord, under two. One is under 2. One is, my lord, 294, that has already been gone, my lord, that all the accused are discharged from 294. Now, my lord, 506. and-
Yes, madam. Heard Ms. A. Gayan, learned counsel for the petition,
They were in love relationship.
and Ms. A. Begum, learned additional public for the respondent of one state of Assam.
I mean, I will.
The petitioners are from one family. So stop. The petitioners are agreed by an order dated 27/10/2025, passed by the Court of Chief Judicial Magistrate, Kamrup Metro Guwahati Trial Court in PRC number 2833/2024, whereby a charge under section 506 IPC read with section 34 IPC has been framed against them. Full stop. By the order framing charge, at the time of order framing charge from the trial court, did not find sufficient materials to frame a charge under section 94 IPC. So, the IO submitted submitted a charge sheet having found privacy material against the offense under section 294 IPC also. Para. From the contents of the complaint, initially instituted under section 156(3), CRPC, and subsequently registered as Bokhisto Police Station case number 306/2024, by the respondent number 2 as the complainant, the complainant had inter alia alleged that she was in a relationship with the petition number 1 during the period from 2/2/2023 to 29/12/2023. Full stop. From the charge sheet as well as from the statement of the complainant recorded under section 164, CRPC, it would emerge that during the period from 2/2/2023 to 29/12/2023, the complainant and the petition number 1 were in a relationship, but on and from 29/12/2023, the petition number 1 left the company of the complainant. Full stop. The complaint was thereafter lodged in March 2024. Full stop. Issue notice returnable on so and so as Ms. Begum for 1. Petitioner shall take steps for service of notice upon the respondent number 2 by speed post within 2 working days from today. Post of having regard to the contents of the complaint, the charge sheet and the statement recorded under section 164 of the statement of the complaint recorded under section 164 CRPC, the there is privacy, no ingredients of the offense under section 506. So it is therefore ordered from India 18 that further proceedings of ERC number so and so presently pending before the court of so and so shall remain suspended till the later date. Before that, scan copy of PS case number we call for issue notice of issue.
Master bless.
Date, please, your lordship. What's a 528 application, my lord? Challenging them on a charge sheet on the proceedings, my lord. The case is of POXO, my lord. notice, my lord, at this stage.
Okay, notice. Heard, Mr. NJ Doctor. You want to say that it has been compromised?
Yes, my lord. And I had filed an FIR prior to this month.
Yes, learned counsel for the petition. And Ms. A. Begum, learned additional public prosecutor for the respondent number 1, state of Assam. First of the petitioner has been solicited as an accused in a charge sheet number 44/2025 dated 30/04/2025, submitted in connection with Fakirganj Police Station case number 16/2025. Full stop. The charge sheet has been submitted. Finding a privacy case established against the petitioner for the offences under sections 3 to 9 within bracket 4 Python stroke 34 stroke 351 within bracket 2 Bharatiya Nyay Honita and section 4 POXO Act 2012. Full stop. The proceeding is presently after submission of the charge sheet, the case has been registered as special POXO case number 167/2025, and the proceeding is presently pending before the court of special judge POXO to be stopped. It is the case of the petitioner that before charge sheet compromise or after charge sheet?
Before charge.
During the course of investigation, after
I'm sorry, my lord,
after submission of charge sheet, the petitioner and the informant, who is the father of the alleged victim, entered into a settlement. Post of in the settlement so arrived, the informant has projected that the affair was outcome of cautionary influence of a group of persons, and not there was no such incident as alleged in the affair. First of, you should notice returnable answers. Let scan copies of TCR be called for steps as Ms. Begum for respond number 1. Steps, respond number 2, post working. This the case also.
Can it be, my lord, on 28 or 29 if possible, man?
We are giving all this because all these are filled up.
If possible.
Because the slot is limited because of many holidays.
Yes, ma'am. On 30, my lord, January. I'm obliged, ma'am. Deeply obliged.
Item 8.
May I please, your lordship?
Yes.
My lord, an application under 552, my lord, for quashing of a my lord, criminal proceeding, my lord. And on basis of, my lord, some affidavit filed by the victims that, my lord, no, my lord, offense as Alice has been taking place. My lord,
What is the FIR?
My lord, on page 20, my lord, vernacular one.
Is it legible,
My lord,
readable?
legible, my lord.
Let us assume that you have correctly translated.
My lord.
I'd like to read for FIR. What is the stage of investigation?
Such sheet submitted, my lord. Cognizance taken, my lord. It is on appearance stage, my lord. Such sheet laid down under, my lord, section 3162 and 3183, my lord.
Where is the charge sheet?
My lord will file the search sheet, my lord. On page 38, my lord.
Page?
Page 38, my lord, the last portion. Other, my lord, that is Bharnigula, my lord. Page 38, bottom, my lord. And translated copy, my lord will find on page 27, the translated one, my lord.
Who are the witnesses there?
My lord, list of witnesses, that my lord will find on page 35.
Page
36,
35,
my lord,
36.
36, my lord.
Where is the FIR? Once again, let us see the FIR.
My lord.
Abu Said is a party?
My lord,
A
Abu Said
witness,
is,
witness,
my lord, Abu Said is not a party, my lord.
not a witness.
Not a witness, my lord. His brother, my lord.
No, I am asking one by one. Javed Ali?
Yes, my lord.
Javed Ali is a witness.
Javed Ali is a Javed Ali
Witness, where is that?
Javed Ali on page 37, my lord. Second, my lord.
Huh?
Page 37, my lord.
Witness number 2, Lord.
Witness number 2.
Zubair or Javed?
Jubaid Ali in here.
No, my lord, at bottom, my lord, bottom. Bottom, my lord, Javed Ali. Is
That is Zahid or?
Javed Ali, my lord.
Huh?
Son of Juman,
Last one, Lord.
last one.
Last one.
Last
Lord.
one, Lord. He is witness number.
AHS. What is
Okay.
AHS? Or Javed Ali is contractor.
Contact.
BDP. AHS. Azad Ali. You typed it as Azad Ali.
Typographical mistake, perhaps.
That is the
Javed Ali.
problem everywhere. In every case.
I apologize for that, man.
Why this mistake occurred for in a English translation for PW1 and PW7?
My lord.
PW7,
My lord.
when it is absolutely clear from page 37, PW2,
My lord.
Zubaid Ali,
My lord.
why you have translated it as Zubin Ali? When it is here is some Zayed Ali, serial number 7, why you have translated as Azad Ali? For what purpose?
My lord, I apologize for
No,
this.
no, one is correct. The two
Mistake.
do not indicate
My lord.
bona fide.
My lord.
Because I asked, I don't know, so I started asking whether
lord.
they are witnesses.
My lord.
If I go to the English translation, none of them,
So, my lord.
because, but in the original one,
My lord.
it is different.
Real.
Javed Ali and some
Jubaid
Zayed
Ali.
Ali. But you say Jubin Ali, Azad Ali. What is this?
My lord, some typographical mistakes. My apologize for
This
that.
is not tolerated. It is deliberate. it looks like prima facie Thursday of deliberation. Why this can happen?
My lord, I apologize
Yes,
for
instead
the.
of A, double A, I can understand.
My lord.
Something has been turned to Jubin
My junior.
Zayed Ali.
My lord.
Name is Azad Ali. What is this? How can you rename a person?
My lord is correct. But I am annexing the original.
Azad Ali and Zayed Ali is completely different.
Different name.
Different.
So how you have done it?
My lord, it
Take a
was.
call, I am not acting on this kind of petition. I am
It's
making it very clear.
Lordship,
But
may kindly
appear,
allow
Mr.
me, with liberty
I
may be
don't know.
granted, my lord.
Huh?
Liberty may be granted, my lord. I will file a, my lord, correct type copy.
It
I
is
will
up
file.
to you.
Liberty may be granted, my lord.
I am not granting any liberty. It is not correct for me.
No, my lord.
No, I have been receiving
My lord.
every alternative petition.
My lord, I apologize for
Mistake,
that, my lord.
Every alternative, initially I used to think that it is not deliberate.
My lord.
Now I am forming a view that this is deliberate.
No, my lord, this is.
The names which have been referred in the FIR
My lord.
and which have been in the search sheet as witnesses, you have changed the name at
No,
least
my lord,
two.
FIR, I have not changed anything, my lord. The original I am annexed. My, I apologize for the inconvenience, my lord. That is, my lord, not deliberate.
Mr. BK Das, Council for
My lord,
application.
I will file a fresh one. Lordship, may kindly grant me
Not-
liberty.
I'm not
My lord,
act upon it. No.
Otherwise, my lord.
So I'll observe otherwise adversely.
My lord, only
It is up
liberty
to
may
you.
be granted, my lord.
5-1.
My lord,
This kind of petition I am not going to enter.
5-1.
Let the other court
Fine,
enter
fine.
in, but not me. Be careful.
my lord,
Otherwise I will record adversely
my lord, my lord,
that this is deliberate.
my lord. With
That's
all due
all.
respect,
That's all.
my lord, I will make. this
That's all.
clear, my lord. Oblige.
Item 9,
You know what? What is it? What's it? You know? That's the damn problem.
Lordship.
Yes, madam.
Separate.
Yes, Lordship.
NIAC,
Lordship.
NIAC, Lordship.
Challenging the impugn order passed,
What is the impugn order?
Lordship, it is at page 49.
Page 49.
Lordship. So here what has happened is, Lordship, the
Is
complainant,
the absent showing cause heard and allowed. Accused person is. The same story.
Lordship.
You keep a judgment on this
Lordship, I'll keep Lordship.
next time.
Lordship.
there is a judgment.
Same story.
Same,
Yes,
all the
judgment
way.
Same story. All are repeating it. You are a complainant.
Yes, Lordship.
Let us stay this order.
As Lordship.
Miss
P. Bora, Lordship.
P. Bora, Learning Council for application. Miss A. Begum. Learned additional public prosecutor for the respondent number 1, State of Assam. This criminal petition under section 528 PNSS is preferred to assail an order dated 10/6/2025. But till that, what has happened?
Lordship, the next date at the trial court is on 24th of December, that is next Wednesday, for cross-examination.
Harder cross-examination.
Yes, Lordship, second time.
10/6/2025, passed by the Court of Judicial Magistrate First Class Kamrup Metro, Guwahati, Trial Court in CR case number 746/2018, full stop. By the order dated 10/6/2025, the trial court has allowed an application preferred by the accused herein, that is the respondent number 2 herein, under section, particularly under section 311 ARPC, seeking further cross-examination of the petitioner complainant. Allowed questioning, allowed questioner, allowed questioner, no stop. The complainant was submitted her evidence on affidavit, and thereafter she was cross-examined, evidence on affidavit as PW1, and thereafter she was cross-examined on 20/12/2024. So stop. The petition under section 311 CRPC was filed on 13/3/2025 on the ground that the earlier set of counsels representing the accused did not properly cross-examine the complainant as PW1. So stop. In the petition, in the application filed under section 311 CRPC, it was represented that the complainant was a money lender, professional money lender, and he used to lend money. He used to lend unaccounted money. Full stop. It was on such aspects the complainant would be required for further cross-examination. Issue notice.
Same. I
Same,
have
all
heard
are
some
same.
judgment.
All-
Thing
Think that others earlier said was incompetent lawyer. So they are wise counsels having more professional knowledge.
one petition is moved and all come in the
Issue
same.
notice returnable on so and so. Steps as Ms. Begum. 1. Steps upon respondent number 2. Speed posts. Having regard to the grounds urged in the application under section 311 CRPC and the manner in which the impugned order and the manner in which the impugned order and having regard to the impugned order dated so and so, comma, this court is of the considered view and the contention advanced on behalf of the petitioner that the impugn order is not in conformity with the provisions of section 300 CRPC. It is observed that, it is ordered that, the impugn order dated 10/6/2025. Operation of the impugn order shall remain suspended till the returnable date.
13-2. Item 10.
Yes.
Wait, please, your lord. This matter, basically, we have come against the decision of confiscation of a vehicle. by-
Confiscation,
Yes, confiscation.
page,
It's a vehicle where legally,
where is the order, confiscation?
that order, there are, one is our Jimma order is there, which was rejected, and there is an order of confiscation, which is at page 16.
1/6.
1/6. Your lordship.
24 is a rejection order.
24 is the rejection of Jimma, but this is the initial order of
No, no,
confiscation.
here you are challenging what?
Jimma, in fact, this is also part of.
Shows
Page
an
16
impugn
is-
order
Lordship-
88.
Yes, page 16,
Page
1/6.
1/6 is order.
Order.
Okay, 1 minute,
The lordship will get to know from this order.
1 minute.
Which is this, 16 or confiscation?
Okay, vehicle has been confiscated.
Confiscated. Lordship,
Right.
under section 6A of the essential commodities.
Right.
Now, there is also a proviso to that act where it has stated in the proviso that if it is a vehicle or animal or something, then if the person, the owner can be handed over on payment of, on lieu of the fine and payment. But that was, option was not given. In fact, the grounds for which the.
Then you filed what?
Against this, we've actually filed a. writ-
Before judicial magistrate.
No, this was, yes, so therefore, page 18.
Huh.
This is the order of the judicial magistrate at page 80. Against that, we have come in now. Now, two things, your lordship. First, as per section 6A of the proviso to section 6A, we are entitled to return of the vehicle on payment of a fine. That was not confirmed. Secondly, in the report order itself, confiscation order, nothing has been stated with regard to the vehicle, whether the owner is liable or whether he is involved or not. Nothing is there. In fact, in the Zimma or rejection order also, nothing has come out. Just because there is a.
You
rejection-
approached by repetition.
Initially,
Petition.
it was somebody approached by.
Now, I'll again put a question
Yes.
for the winter vacation. This order of confiscation has any criminal color or has civil color?
It is.
Passed by district magistrate.
Yes.
Yes, there can be criminal prosecution
Criminal proceeding.
as well as confiscation proceeding, right, proceeding. Now, both can go together, but independently. Now, this order has civil color or criminal color? Confiscation order passed by district magistrate, right? And against that perhaps appeal lies before a particular authority under section 6 perhaps
That is there.
there.
6C,
Now,
6C.
if you challenge this order before a judicial magistrate, he perhaps is powerless.
He is under 6C.
Ah.
He will come because he is a judicial authority.
6C, let us see 6C.
There is no specifically stated that he should be a certain officer or so, but it is stated that it should be a judicial.
Hmm.
officer.
Hmm.
Judicial.
Right,
So that
right.
is the reason
Ah.
the magistrate. comes.
So, you go through established precedents, whether criminal powers under, say, CRPC, can be made available to set aside an order of confiscation. To my knowledge, 482 and all are ousted. So please have it because, and it also says line of precedence that it is power of judicial review, 226. So there is an order already. So you just have a look.
No, because of
And-
that, I'm just trying to point out.
Come back.
I am also, when this matter came to me, I was not earlier there. When it came to me, I initially saw the order of the, in under 226. The order in 226 that you approach under 482. That is why there is no other option, your lord.
Which? Oh,
This
no,
order.
order is there. Oh, no, this
Yes.
order is there.
Yes,
I am saying about
yes, your lordship.
line of
Yes, yes.
precedence.
I
Uh,
I have also talked about.
There you'll get at least 5
Yes,
that from Supreme Court.
yes, yes.
Power under 482 is ousted.
That is why your lordship 226 was there.
Right. So let us, that is why I said, just we'll relook
Now,
at on
that
6th
is-
of January.
That is the reason, your lordship, why I felt like, because there is an order to approach under.
Right.
Just
No.
pointing it out.
Without going
Yes.
into that,
One
let
more
us
thing.
have it
Yes.
once more on 6th of January. Today is the last day that
Yes,
exercise is
exactly.
not possible. We go through it.
Now, I will go through it, but my part also I'm trying to point out. I also went through it. I told my junior that this is how we will go about it. I am also a bit confused because this is it.
And there-
Secondly, then I said, okay, then you have to strike only on the Jimma part because that will come.
That
under
is, and again, different, that is
That will come under the criminal.
some overlapping situation.
Yes. So
Right.
that is why I said you have to strike to the Jimma also. So we brought in the Jimma. That is the reason we brought in both.
I had Mr. Y.S. Manan, learned counsel for the petitioner, and Ms. A. Begum, learned additional public prosecutor for the respondent state, as sought for by the learned counsel for the parties, leads the case on 6th January,
So can it
Will
be
it be all right?
7th, your lordship, 7th?
7th. Okay, 7th.
Obliged.
Item number 11.
Yes.
My lord will take the Drugs and Cosmetics Act also by side. Just before your lordship looks into this matter,
Ah.
I just want to point out, my lord, this petitioner, my lord, is a lady of 84 years.
You want to say that you are not part of the
Right, your
company,
lordship was-
right? You are not in charge of
Correct,
day-to-day
correct,
affairs
correct.
or connected with the affairs of the
Absolutely
company
correct, my lord.
prior to institution of the,
Absolutely right.
right?
Right.
That is the
absolutely-
case.
Absolutely correct. I don't have to say much.
Okay then. What is the section otherwise in the Drugs and Cosmetics Act
Yes,
that likes
yes.
141 enact?
Yes, it's right. And there is one, your lordship is acquainted with a lot of judgment. I found one judgment in 2025 that passed by the Honorable Supreme Court. What your lordship has said, that whether you are with the harem affairs of the company, that in the 483 itself, it was set aside by the Supreme Court.
So anything from any document
That's even-
like that, say ROC?
I will show, yes.
Ah.
My lord, that is your lordship will kindly see, which starts at page 26, kindly see, my lord.
Give me one document.
26,
Ah.
26, my lord.
One thing
This
is there, you cannot lead negative evidence,
Yes.
but still,
Yes.
who are the,
Yes,
the
correct. Yes,
directors.
I know, that's your lordship will want to know that
who
100%.
are the present board of
Yes,
directors?
I will show it.
That's
Page
all.
26, my lord.
Page 26.
I have given 4 years from that. See 26, form
Ah.
number, lordship got it on the right.
MGT.
7, annual return. Now kindly see, my lord, the name of the company, Concept Pharmacy,
Hmm.
1, 2, A, lordship got it. Now next page, please turn to make space 27.
27.
27. See, Roman 7, financial year 1/4/2019 to 31/3/2020, lordship got it. At 7, financial year,
Page 27.
27.
Financial year.
Yes. So
Ah.
lordship got it.
Ah.
See, 7,
2019 to 2000.
20. 20. I have all. Now, page 35, kindly look into it. Who are the directors? Kindly see. Directors, my lord.
These three,
Yes,
okay.
these three director
Mm.
and kindly see, my lord, the list of shareholders. They are also, this lady also doesn't reflect that page 40. List of shareholders at page 40.
You have made a statement.
Yes, yes, and I have annex also. I have annex. See this
Hmm.
list of shareholders
Hmm.
at page 40.
And where is the complaint?
Ah, yes. Complaint, please see complaint at page 110 and para 27.
110.
0. And she is
Union of
accused.
India.
Yes, number 5, my lord. At page 111.
It was in 2023.
Yes, right.
And anything visit or something on which date?
They visited somewhere in 2019, my lord.
2020.
2020. 2020.
Which page?
My lord. Page.
Abu so and so is
Yes.
filing in the
Yes.
from the so and so.
My lord, we will find at page 20, para 27, or 123, my lord. What is the role at 123, para
no.
27?
Somebody visited some
Yes.
inspector visited.
Yes.
Para
Para
three,
3, my
page,
lord.
page.
Para 3
Date,
of
date.
page
Any date?
113, my lord.
Any date?
Yes. Date is, they visited.
Sample.
Yes.
Prosecution
Para.
permission. Is filing. 29?
September.
Yes, Mr. Medhi. What is the section?
My lord, 27D, my lord.
What is the section?
34. 34.
27D, my lord.
34.
My lord, this complaint is, my lord, under section 27D, my lord. Page 112, 112, my lord.
Offense by company is 34.
So company is the accused number 1.
Yes, my lord.
So thereafter the vicarious liability. It would be all the directors perhaps offenses by company.
Yeah.
34-2.
Right.
Ah.
And 34 to exactly bang on that judgment, latest judgment of 2025.
Heard.
I'll show later on. By
Mr. D. Das, learned senior counsel, estate by
and
J. Bora.
on my learned frame, my lord, your
And
documents
Mr.
come from Bombay.
Jahangir. You give the name,
Yes.
learned counsel for the petitioner. Mr. Medhi, you, okay, so
Next
respond.
next day is, my lord, in applicant 7th January, my lord. 7th January next day. Next day in the court.
No, I'm not staying the whole proceeding so far as the petition is
On
concerned.
6 lordship may heard, my lord, I'm not, today, my lord, just I received the copy, my lord.
But I am convinced. Mr. S.K. Medhi, learned Central Government Council for the respondent, Union of India. Full stop.
My prayer may be recorded, my lord.
A complaint in the form of CR case number 139 Uparot capital C. Stroke 2023. Got instituted before the Court of Chief Judicial Magistrate Kamrup Metro at Guwahati on behalf of the Union of India through a drug inspector. Page 110, huh? O-stroke O, Assistant Drugs Controller, India, Central Drugs Standard Control Organizations, so and so. Full stop. In the area of respondents, comma, Messrs. Concept Pharmaceuticals Limited. Area of accused. Messrs. Concept Pharmaceutical Limited. has been arrayed as accused number 1. And the accused number 2 to 8 have been implicated on the ground that they implicated on the ground by on the concept of vicarious liability. So stop stating that accused number 2 to 4 are directors in accused number 1 company. So stop. The petitioner herein has been arrayed as accused number 5 in her capacity as a subscriber of accused number 1 company. Full stop. The other 3 accused persons, that is accused number 6 to 8, are projected to be associated with the accused number 1 company in different capacities. Full stop. Para, it is the case of the petitioner that the petitioner is neither a director nor she was neither a director nor she was associated with the accused number 1 company as manager, secretary or other officer of the company much prior to, from a date much prior to 29/9
Yes.
2000
20,
20
20.
2020 when the drug inspector seized
Yes.
a sample of tablets, allegedly manufactured by the accused number 1 company, from no, not required.
No, the name is T. Yes.
No, where from it was seized? Where from it was seized?
Central Medical Store.
Where it is written?
5 of the.
Paragraph 5.
Yes. Paragraph 5 of
Ah,
114.
Page 114. Central Medical Store,
Yes.
NF Railway,
Yes.
Central Hospital,
Maligaon.
Maligaon, Guwahati. Right?
Yes, correct.
2909, right?
Yes.
So submission notice returnable on so and so. As Mr. Mehdi, CGC, sole respondent. Having regard to the contents of the complaint lodged in connection with complaint case number, CR case number 139/2023, and the provisions contained in subsection 2 of section 34 of the Drugs and Cosmetics Act 1940, it is observed that it is ordered that further proceedings of CR case number so and so, insofar as the petitioner, who has been arraied as accused number 5, is concerned, shall remain suspended.
I am deeply obliged.
13-2.
Oh, before that, Mr. Mehdi, Central Government Council has objected, has submitted that the petitioner was what, founder of the company? Was the wife of the founder of the
Founder.
company, founder of the accused number 1 company, and she was associated with the accused number 1 company. And as such, her arraignment as accused is proper.
But all these cases, my lord, same thing, my lord. All these tax cosmetic act, my lord, my lord, the family is involved, my lord.
Vicarious liability concept is not
Yes, yes, yes,
ordinary by statute.
I understand, my lord.
Have you found anything in IPC? No.
No, my law does not.
Vicarious
but-
liability is
but
different
next-
thing.
Next,
I'm deeply
And
I understand.
the Supreme Court is involved with 141 in NI cases for 1 lakh, 2 lakhs, all these judgments.
I understand. Next, that,
Ah.
in that.
So many
13.
hours are
Right.
wasted.
Yes, man.
Deeply obliged, man.
Highly obliged.
Item 12.
Copy आता दीजिए.
Yes, Mr. Bhuya.
May it please the lordship. The petitioner herein are challenging, my lord, the FIR of Laluk PS case number 170.
FIR.
So lordship, notice.
POXO will call for the case there.
My problem is,
Can copy.
my problem
Your
is,
problem, you keep it with you.
but with a medical report, your lordship, for kindly, for a minute, my lord, but no, my lord, medical report is in positive, my in favor of the,
That does not,
my,
pregnant, lord.
does not fall.
The girl is pregnant.
pregnant, or my lord, pregnant, already, my lord,
Okay,
medical
let us,
case-
for your satisfaction, let us
my
see.
lord. The next date is tomorrow, my lord.
No, that is different thing. Just because next date is tomorrow will not pass in your, let us, have you not made it?
My lord.
I might dismiss it also.
Yes, my lord.
I've been dismissing it.
Yesterday, I have gone through your lordship's judgment, my lord.
No point keeping it pending.
My lord.
Let us have page 21. Because of the last day, I did not go into it.
Yes,
Let
yes,
us
my
have
lord. Notice may be issued, my lord.
14 years,
16, my lord.
16.
Yes, my lord.
Okay, 16 is okay.
My lord. But my medical report says
Took her
otherwise.
to
my lord.
Ganga of Arunachal Pradesh.
The incident was of
He
7:10,
kept her
my
in a
lord.
hotel, established and so, dropped off after 4 days. We have rescued.
For a moment, page 30, my lord.
Then search it.
Lordship,
Her statement is available.
no, my lord, a certified copy is not provided. my lord.
164.
Certified copy is not provided, my,
That we have to see.
my lord.
Medical
kindly-
evidence,
kindly for a
medical
moment,
evidence
please.
is not the determinative factor.
My lord, page 30,
Sole
my lord.
determinative. Heard Mr. T.K. Bhuya, learned counsel for the petitioner, Ms. A. Begum, learned additional public prosecutor for the respondent state. This has to be by that police station, officer in charge.
For registry,
Service?
my lord.
Through registry,
For
lord.
registry, my lord.
To raise your,
Try.
There is a
no,
procedure.
No.
service of notice.
Procedure to.
Upon the
There is a-
informant, police station.
Police station, lord.
PP, my lord.
Okay. Okay, for the petitioner hearing has preferred the instant criminal petition under section 5 to 8. Bharatiya Nagarik Surakha Act. Cross-title sub. For setting aside. 1. A first information report dated so-and-so, registered as Laluk Police Station, first number so-and-so, dated so-and-so, submitted in connection with Laluk Police Station case number so-and-so, and the proceedings of special, POXO case number 53/2025, presently pending before the court of the special judge POXO, Lakhimpur, not Lakhimpur, special court for short, full stop. Issue notice returnable on so-and-so.
4-2.
Let the scanned copies of special case, so-and-so case number be called for. Issue notice returnable so-and-so. As Ms. Begum has appeared accepted, respond number 1. The petitioner shall take steps for service of notice upon the respond number 2 and 3 in terms of notification number so-and-so. Dated so-and-so. The learned additional public prosecutor shall obtain a report from the officer in charge, Laluk Police Station, as regards service of notice. Victim, why victim is required?
Because but there is a settlement procedure already is there, my lord.
She is a major.
No, my lord.
As on date?
Her name may be struck off, my lord.
No, then only two. Only two. Father, he is a father,
No, my lord, brother, my lord.
brother. This
Maybe struck off, my lord.
will not go into that.
My lord.
Response number 2. Officer in charge and to place the service report on the next date of listing.
I am deeply.
Item 13.
Yes.
28 application, my lord. I've challenged a for quashing of FIR. So far is my role
Which
is
page?
FIR is just page number 18.
You are Orup Pathak?
Yes, my lord. I've been added as case number 4.
In absence of house is at Haju. How you went there from Guwahati?
I
Night.
went there. Yes, my lord. I went there with my friend, and the informant is my maternal aunt, own aunt.
Okay.
And that sister of the her daughter-in-law called me
Your
up.
mommy?
Yes, my mahi.
Mahi?
My mahi, yes. And the sister of her daughter-in-law called me up for bring some food. Sister of the daughter-in-law.
Sister of her daughter-in-law.
Yes, yes.
So many-
She has been added as respondent
Sister of
accused number.
her daughter-in-law. Daughter-in-law means
Buhari.
No, Buhari's
wife of Biswajit Das.
yes.
And
She was also
Biswajit
there.
Das' sister-in-law.
Yes.
Ah.
She was also there. She called me up to bring some food, fast food items. So I went there and delivered the food in the veranda and went back with my friend. He was also there. And kindly see, my lord, the incident took place on 10/10/2025 and the FIR has been filed on almost after a month.
Miss Begum, what is this? Maybe he was in there, but there is no offense alleged against him. First line, page 18.
Lordship,
That he entered into my house in their absence
India.
In their absence.
up to 10:45 or what? Stayed there for late.
And they drove.
Nothing alleged. Nothing has been alleged against him thereafter. He stayed there.
Lordship,
And it is not a case of perhaps is criminal trespass is there.
House
that
trespass.
is Lordship.
House trespass
House
is there.
trespass is-
House trespass.
Okay. But they were not there. Somebody might be there. If,
Somebody is there. Lordship.
then if it is with that person's consent,
Lordship.
how can it be criminal trespass?
Lordship.
And there is no allegation of unlawful conduct.
Then,
Something is there between.
and my daughter-in-law was,
And that is daughter-in-law.
how can you stop that?
Cannot, but Lordship. Notice, Lordship.
What is the case? It resulted in the search sheet.
That
No, no, no.
defamation, Lordship.
Huh?
Defamation. Defamation is also there.
So after
I have
investigation, what happened?
I have served a notice for defamation. In reply, they
No, those are different things.
those are
But
different issues.
after the FIR,
After the FIR,
what
my
is the
statement has
present
been
stage of
recorded,
proceeding?
but I have been almost every after alternative day called by the investigation agency. Already this statement has been recorded. My pair is
No
only-
charge sheet.
No.
No charge sheet.
No
is
charge sheet,
issued.
yeah.
Then we need to have the case diary then.
Then
Yes,
case
yes.
there, Lordship.
Let us have case diary, but because investigation is
all
not to be
qualified.
stopped. Then urgently you get the case diary. Or
Lordship, immediately
can you?
opening,
Huh.
opening. Lordship.
Heard Mr. S. A. Roy, learned counsel for the petitioner, and Ms. A. Begum, learned additional public prosecutor for the respondent state. We are not issuing notice then, or returnable. Make it returnable.
Lordship.
Oh, informant is there.
Yes, ma'am.
Informant is there.
Then. Okay, we make it 20 or 19. You take steps.
My lord.
Response number 2, day, PP. Huh? Issue notice returnable on 19, 1. Reasoning 19. About 2020. Steps, response number 2. 1, a speed post. Learned additional public prosecutor shall obtain the case diary of Hajur Police Station, case number 463/2025 on the next date of listing. That is the one case?
My lord, the investigation agency already.
Investigation, I
extended-
don't stay.
Supplementary list, item number 17. Item 17.
Yeah, we should just 10 minutes करना उठी हाँ Mr. Kotogi, for 5 minutes. EC Act against confiscation order.
Yes, madam.
There is an appellate authority. There is, I have found one.
Actually, I appeal lies to the district judgment.
Ah,
Normally in forest cases,
right.
district judge against that order.
It is Judicial Authority 6C.
Yeah.
Now, in this thing,
It will be a civil
Mm.
proceeding.
it will be civil proceeding.
Yes, ma'am. Against that order, writ
Ah.
petition lies.
Appeal lies before any judicial authority appointed by the state government concerned, right? So, Ms. Begum, in Mr. Mannan's case,
Yes, Lordship.
you get a notification,
Lordship.
copy of the notification, whereby the judicial authority has been appointed by the state government,
Lordship.
right?
Lordship.
Because judicial magistrate first class, he exercises criminal jurisdiction,
Lordship.
Right.
Lordship.
so that part,
Lordship.
I need to know, I don't have the notification.
Lordship, I'll give.
In item number, Vice Manan Kiman,
Lordship. That is like 10, Lordship.
10. As
Against the
per,
finding of the district judge, writ petition linked.
right. That is a different route.
Different rule. It's
There is a-
administrative order, ma'am.
There is a judgment of Justice P.G. Agarwal in forest case
Yes, ma'am.
that this district and session judge exercises two jurisdictions.
Two jurisdictions.
One criminal jurisdiction, one civil jurisdiction. Now, if district judge signs that order as a session judge in a confiscation proceeding, that is bad.
Then cannot do.
He has to sign that order as district judge,
District judge, ma'am.
Lordship.
right?
Lordship.
So
The notification.
he district and session judge, that is why he called district and session judge.
Lordship.
लिखा केनेके as per section 6C of the Essential Commodities Act 1955, 6C1, subsection 1 of section 6C, comma, an appeal against an order of confiscation under section 6A lies before court any judicial authority appointed by the state government concerned. Unquote. Full stop. Published next line to differ. Ms. A. Begum, learned additional public prosecutor, shall apprise this court whether any appellate authority under Section 6C within bracket 1 of the Essential Commodities Act has been appointed by the state government by and if in the affirmative, then the concerned notification
Lordship.
issued
Lordship.
in that connection be produced. The name of Ms. A. Begum be
This
reflected.
is old act. Most probably it is done long back.
Long back. So it will be taken. Bring
Lordship,
it.
I can bring, I'll take the order,
Ms. A.
online
Begum,
order. I'll
and
take
the
it up.
name of so-and-so be reflected in the cause, respondent side the cause list. Otherwise, again, we have to,
Lordship, then I'll take out the online order and I'll pursue with that. Lordship.
yes.
Also. The prisoner before Lordship, my lord.
Hmm?
He was a
Washing or what?
passing of a charge, my lord. I was
Washing of a charge. Where is the charge order?
charge order, your lords will find at page, starts from page 36, my lord.
36, Ishan Soikia.
Matter relating to 494, my lord. Second marriage.
Second marriage.
Children public perused. Leading to the institution is that 2.5 years before filing the affair, married the accused by way of Hindu rites. In their marriage, the accused is torturing the complainant under money on the emperor was accused, married. And now his second wife came to live in their complainant was asked to get a divorce. But as the Nag Sankar Devala is appended along with the complaint. What is 494?
494,
Second
my lord.
marriage. Having.
IPC.
Were having a husband.
Marrying again during lifetime of a husband or a wife. Whoever having a husband or wife living marriage in any case in which such marriage is void by the reason of its taking place during the lifetime of such husband or wife shall be punishable with so and so.
494, marrying again. Now come to page 38, Ms. Begum.
Lordship,
Once evidence is adduced by the prosecution, in this case, the materials can be established against the accused.
accused persons.
What is that? DM Sarkar?
Yes, sir.
DM Sin?
Yes, sir.
I think your
Yes. Citation was, there is our High Court decision is there, man.
ALR,
ALR.
1970.
1971.
Okay, heard Mr. P. Kotoki. Learned counsel for the petitioner. Ms. A. Begum, learned additional public prosecutor for the respondent state. First of issue notice returnable on so and so. As Ms. Begum has appeared accepted, is on behalf of the respondent number 1, State of Assam. Issuance of formal notice to the respondent number 1 is not necessary. Extra copy within 2 working days. The petitioner shall take steps for service of notice of the respondent number 2 by speed post within 3 working days from today. To stop. Para. The petitioner in this criminal petition under section 528 ENS 2023 has sought setting aside and quashing an order dated as inter alia. Sought setting aside and quashing of criminal proceedings of ER case number 2154 2024, presently pending before the court of Chief Judicial Magistrate, which place? Nagaon.
Nagaon.
And also an order dated 14/8/2025, passed by the trial court. First up. Para. By the order dated 14/8/2025, comma, the trial court has proceeded to frame a charge under proceeded to frame charges under section 494 IPC and section 506 IPC against the petitioner. Full stop. Para, like in the para, in the order framing charge, in the impugn order framing impugn order dated 14/8/2025, framing charge, comma, the trial court has observed that the prosecution side had failed to show that the petitioner threatened the informant with serious consequences on 9/5/2019. Full stop. In the before the trial court, comma, it was submitted by the prosecution side that once evidence would be adduced by the prosecution, then the materials regarding the offense under section 494 IPC would be established. Full stop. Para. No, the petitioner has however been discharged from the offenses under section 294 IPC and section 447 IPC by the order dated 14/8/2025. First up, having regard to the position made on behalf of the petitioner and the observations recorded by the trial court in the order dated 14/8/2025, comma, it is ordered, comma, in the interim that further proceedings of PRC number so and so presently pending before the court of so and so shall remain suspended till the returnable that Taragote Likhibo issue notice to Bishop. Let scan copies of the PCR recall.
13-2. Item 18.
By please, Lordship. In this case, challenge is made to the legality of order dated 27/10/2025 passed by the learned special judge and thereby extending the statutory period for completing investigation for further 90 days. Page 57 is the impugned order law. This is an NDPS case. During the pendence.
Today is fixed. Paying for extension EP. It is treated with commercial.
Commercial loss.
What is the grounds of challenge?
First ground, Lordship, notice has to be issued. Now, here, what happened? On the last paragraph, page 59, learned special judge observed that copy of the petition was served to the learned counsels of the petition. Now, this is an investigation stage. If anyone appeared in a bail, filed a bail application was disposed of, then cannot be said that he is representing this accused person. And
That would require some deliberation.
yes, Lordship. And another point is reports. 36A says, 36A4, proviso says, Lordship, if I may read, provided that if it is not possible to complete the investigation within the said period of 180 days, the special court may extend the said period up to 1 year on the report of the public prosecutor, indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period of 180 days. So report of the public prosecutor is required. It is apparent from the order, page 58 also, that it says in view of the above provision and considering that the customs preventive force has filed the petition before expiry of the statutory period through the learned special PP, citing valid reasonable ground, I find the prayer to be justified. Accordingly, the petition number such and such filed by the informant customs preventive force, though through
Where
the
is the
learned
petition?
Lordship, yes. Petition I have annexed is page
I have seen 52.
52. My humble submission, Lordship, would
We
be
can call for a scan copy.
yes, Lordship.
Th-
Because
this
he
is-
has become a party to the investigation. Public prosecutor become a party to the investigation.
No,
His report was
if,
required.
if the IO files an application that it is to be outrightly rejected,
Rejected.
right? It is the public prosecutor who has to apply his mind.
Apply his mind by
Right.
report.
So, yes, based on materials. That part is to be on merit,
Merit.
whether he applied his mind or not. Second part, what you argued,
Notice.
that
what-
notice,
Notice.
that is also to
He
be
is in
seen.
jail.
Otherwise, if only engages in bail, where from whether it is requirement, it is a requirement to serve the notice upon the accused or through his counsel. What is
Accused.
the law?
Lordship. Accused.
What is the law?
It is been decided, settled position, it wasn't accused. It is not a
What
trial.
is the law? What is the, where it is laid down?
In this case, report part also, it is a 3 judges bench, Lordship, Hitendra Vishnu. It was a Tada case. Lordship, you can page 30.
Hitendra Vishnu Thakur.
Yes. I am
Yes,
referring paragraph 20, starts from 11.
Paragraph 20.
Lordship, may kindly come to page 13, second paragraph.
Second.
It is long paragraph.
Let us have so that my memory is also refreshed.
Yes.
Ah.
Thus, we find that once the period for filing of charge sheet has expired and either no extension under clause BB has been granted by the designated court or the period of extension has also expired, the accused person would be entitled to move an application for being admitted to bail under subsection 4 of section 20 TADA, read with section 167 of the code, and the designated court shall release him on bail. If the accused seeks to be released and furnishes the requisite bail, we are not impressed with the argument of the learned counsel of the appellant that an expiry of the period, on the expiry of the period during which investigation is required to be completed under section 24 TADA, read with section 167 of the code, the court must release the accused on bail on its own motion, even without any application from an accused person on his offering to furnish bail. In our opinion, as an accused is required to make an application if he wishes to be released on bail on account of the default of the investigating prosecuting agency, and once such an application is made, the court should issue a notice to the public prosecutor who may either show that the prosecution has obtained the order of for extension for completion of the investigation from the court under clause BB, or that the challan has been filed in the designated court before the expiry of the prescribed period, or even that the prescribed period is actually not expired and thus resists the grant of bail on the alleged ground of default. The issuance of notice would avoid the possibility of an accused obtaining an order of bail under the default clause by either deliberately or inadvertently concealing certain facts, and would avoid multiplicity of proceedings. It would therefore serve the ends of justice. If both sides are heard on a petition for grant of bail on account of the prosecution's default, similarly, When a report is submitted by the public prosecutor to the designated court for grant of extension under clause BB, its notice should be issued to the accused before granting such an extension, so that an accused may have an opportunity to oppose the extension on all legitimate and legal grounds available to him. It is true that neither clause B nor clause BB of section 4 of subsection 20 TADA specifically provide for the issuance of such notice, but in our opinion, the issuance of such a notice must be read into these provisions, both in the interest of the accused and the prosecution, as well as for the doing complete justice between the parties. Because it was during the pendency of the investigation. Today, I appear in a bail application, it is disposed of, rejected. So, the day after tomorrow, another counsel can appear.
And what are the subsequent decisions on this point?
Subsequent decisions that I have not done through regarding lawsuit. It is the
Also go through. Also go through. Law develops.
yes. Okay.
Law
That is the
develops.
pre-judge's bench, that's why I was
Law develops from time to time.
time to time.
Because this law that
94.
say this one. In our opinion, as an accused is required to make an application if he wishes to be released on bail on account of the default of the investigating or prosecution agency. And once such an application is made, the court should issue a notice to the public prosecutor, so and so, so and so. That has been changed now that an oral application can be made.
No,
The
this
law
is
changes.
because the report is required, so a report is
No,
that
no,
cannot
no,
go
I'm
back.
saying that
Oh, this default bail.
this first part,
Oh,
there are
default
two
bail.
parts
Yes,
to it.
yes.
That initially said an application must be made by the accused for default bail.
Default bail.
Now that has been changed
Yes.
to a certain extent in Rakesh Pal, that
Yes.
oral application can be made and magistrate is bound to consider default bail. Law changes from time to time. মই এটা দিছিলো চাবচোন সেইটো এটা আছে এই যে এছনমাজৰ এটা আছিল সেইটো লেট হ'বচোন because I have dealt with the issue, I have forgotten. There are some judgments in similar lines were placed. What to do, madam?
Chief, we will file a reply or not.
Reply. When?
Chief, after 10 days, 10 days may be allowed.
After then,
Before Bihu vacation, maybe.
not Bihu vacations.
Lordship,
It will be
90 days will be
will
over.
be too constrained. Already we have posted many matters from January 1st week to.
Now, after that, another date will go because they will submit reply only.
No, we both will see the scan copies also. Because this notice must be placed before the court also.
Yes.
But it will be too voluminous, relevant part, or it will be too voluminous otherwise, NDPS.
Yes.
Is it not?
Otherwise, I have annexed all the documents, complaint petition.
Where is your notice?
No notice was issued.
To whom it was served?
Oh, it was served as per the order, the complainant lordship.
No,
Yeah,
last page,
Counsel.
59. Who is the counsel? Mr. Purakasto?
Oh, it is in lordship. This is not clear because I did not find any okalatnoma by the accused person.
Present petition was filed on 24/10/2025 and the learned counsel appearing for the accused received a copy of the petition on the same date.
Yes.
Right?
Yes.
There is a statement by the court.
In the petition, there is a signature lordship, but I did not find any okalatnoma of
Petition, where is
of
the
the
petition?
petitioner.
Where is
Page
the
50
petition?
Page 52 lordship.
Received
There is one
with objection.
another two. There are three accused persons actually in this case. I did not find any okalatoma by petitioner.
Heard Mr. S.D. Purakasto, learned counsel for the petition. And Miss
M. Deca.
M. Deca, learned counsel On behalf of
SC Cal.
SC Cal, Learned Standing Council Customs. Standing Council or Public Prosecutor?
Public pros-
Public Prosecutor, Customs, for the respondent. So, in departmental case number is 57 class. There are 3 accused, namely, no, page 52, 1, 2, 3. 3 accused with the petitioner. So stop. The case has been registered for the offense under
29.
Charge is there.
No, charge sheet is not filed, Lordship.
Okay. The case has been registered.
It is extension of investigation.
No, just
Yes,
for the
they filed
offense
complaint.
under section,
Complaint filed under section 36A
in a complaint and filed under section 36A
of the
NDPS
NDPS
Act, comma, the accused, 3 accused persons, including the petitioner, have been charged for the offense under section.
they have mentioned there somewhere.
So it is in the offense report.
Complaint filed.
Ah.
Investigation is pending.
So how can it be? It is complete. Complaint 36-4 is complete. There cannot be charge sheet. Because customs has to
Yes.
file the offense report stroke complaint, not charge sheet. They are not authorized to file charge.
Yes.
So it is, investigation is complete. Is it not?
No, that's,
No.
it is not,
Maybe
it is not.
part
complete.
charge sheet.
No, they have,
Let us see. Let us see the order. Oh, no, 36A4 extension. Okay.
A4 is the extension.
What is the offense registered? Sir?
That is, it is specifically not mentioned in the complaint.
No, FIR has complaint, okay. Under section 8, small c, comma, NDPS Act, which is punishable under section 21, small c, and section 29 of the NDPS Act 1985, post of para. On 24/10/2025, comma, a petition seeking extension of the statutory period to complete the investigation was filed before the special court, Kasara Silchar, on the ground that the statutory period to complete the investigation was going to expire on 27/10/2025. Full stop. The accused, charge-sheeted accused persons no hari. Charge-sheeted what to carry. The accused persons were arrested on 2/5/2025. Full stop. In the petition seeking extension, comma, 2 grounds were urged to submit that 2 grounds were urged by the learned public prosecutor while seeking extension. Full stop. Para, Mr. Purocas, learned counsel, appearing for the petitioner, has submitted that the case was at the investigation stage and an obligation was cast upon the prosecution to serve the prior notice upon the accused only and none else. Full stop. He has further
Upon the court
submitted
also.
that reports, what do you say? Report.
Report of the special person.
Huh?
Report.
He has further submitted that a report of the public prosecutor is a sine qua non for seeking extension, right? Issue notice returnable on January 20. বন্ধই নহয় 28
On that, Your Lordship,
the respondent customs authorities shall file their objection prior to 28/1/2025 by serving an advance copy to the learned counsel, but a petitioner. Full stop. Our likhok, let scan copies of the relevant let the relevant parts of the TCR pertaining to the proceedings regarding extension of investigation period be called for. Because otherwise all these voluminous.
there is no other procedural, this departmental case number is only there. Okay.
Departmental case number, sorry.
Lordship, may I,
Ah,
these two things, Lordship. On 28, Lordship, by 28, this extension period will be over.
oh,
So maybe,
okay, let it be on then 19.
Lordship, much obliged. And another point, Lordship, the notice has to be also issued by the court also. When it is not only prior notice by the prosecution, notice to be by the court also.
Okay, here as that the notice for extension has to be by the learned, has to be by the court. Has to be by the jurisdictional court, because that court is not trial court till then. It is at a stage of inquiry,
But otherwise, special judge will be the
not inquiries, investigation. only.
investigation designated court.
Okay.
Obliged.
Good evening. Yes, next to Kojo.
May I please it? Your Lordship, this is under section
482,
528 of.
528, yes,
Yes, Your Lord.
yes.
The FIR Lordship. Annexer A Lordship, page number 15, Your Lord. I have sent it
Yes,
the then
I'm going
FIR,
on
the search
first
report
one
and the
person.
subsequent proceeding date.
Shikha Das. Kodukon.
Is for false malice.
Then what happened? Charge sheet.
Your Lordship, in the instant FIR,
Charge
Lordship,
sheet.
victim. Yes, Lordship.
Charge sheet.
Charge sheeted
Ah.
and thereafter the proceeding is going on before the learned.
Charge sheet. Let us see the charge sheet.
Looking Lordship.
Charge sheet.
Having charge sheet number, Your Lordship, 30th of To Lordship, search sheet number, Annexa B, page number 19, Your Lord. After 4 days, Lordship, search sheet has been submitted by the investigation officer, Lordship, wherein Lordship categorically mentioned the relevant page, Your Lordship, that is page number 28. The said search sheet, Lordship, the investigation itself verified that, Lordship. The victim has came out from the hotel room at around 6 p.m. Lordship, and they both were entered into the said hotel, Lordship, at around 3:5 p.m. Lordship, but subsequently the victim.
You have appeared before a trial court.
Yes, Lordship, trial court, Lordship, I got bail, Lord. I appeared, Lordship. The proceeding is going on, Lordship.
What is the stage?
For appearance, I have already been appeared.
You are the only one.
Yes, Lord.
Trial.
Yes.
Well,
I
you
have
should
appeared.
notice at this stage.
So, Lordship, order may can be granted as because, Lordship, there is a contradictory statement.
If you-
itself, FIR as
If
to
you
the
want
search sheet.
for a stay, then I'll go through the merit.
Definitely, Your Lordship.
Okay.
The FIR,
Okay, then.
that is the
Here may
contradictory
be called for, my
statement.
lord. Trial court record may be called for, then, my lord, then all this trial court record may be
No,
called
if
for.
at the stage of motion,
My lord. My lord.
if
at
I
least
go into
notice
the
may be
merit-
issued. Notice may be issued, my lord.
no, I may dismiss it also.
My lord.
When I say,
My lord.
then I dismiss.
go to
I have
merit.
been dismissing.
Quasi-
Where I
search sheet,
think
my lord.
that's the case, I'll issue notice, otherwise I'll dismiss. At two.
Your Lordship, it's a notice.
No, no.
It's a notice, Your Lordship. May I please? Your Lordship, FIR Annexa A, Lordship, page number 15. May I please to read it?
Now 69 is a new offense now.
Yes, ma'am. Search sheeted, madam.
69 is a new offense in BNS. It was not earlier in
Yes.
IPC. Not earlier in IPC.
Punishment after 10 years. Sexual intercourse by employing.
What is the
deceitful
statement of the informant?
Your Lordship. Annexa G, Lordship,
Annexer G,
page number 41.
41.
Translated in type copy, Lordship.
Let it scan copy be.
Scan copy be
part
copied.
Mr. M. Soikel and counsel for the petition. Mr. M. P. Gupsami, learned additional public prosecutor for the responding state. Respondent of one state. Full stop. Writ notice be issued. The notice is made returnable on so and so date. As Mr. Gupsami has appeared, accepted notice. For respondent of one state. Formal notice is not necessary. Extra copy. 2 working days. Steps upon respondent number 2 by registered post AD. The scan copies of PRC. Any case number? PRC case number?
No, Lordship.
Huh?
No PRC case number. This one case number, Lordship.
Any GR case number?
Case by GR case. This one case number 102/20.
Not sessions case number.
Yes,
Where is it is mentioned?
Lordship, in my PR portion, Lordship, that has been mentioned.
Prayer portion.
Yes. Page 13, Lordship. Case number 12 as well as 13.
Okay, sessions case number 102 through 2005 B call.
If
Yes.
May I please, your lordship? Lordship, we have filed this revision petition against the impugned order dated 8/12/2025 passed by the learned Special Judge POCSO in case number 105 of 2025, whereby prayer for being released on the ground of default bail was rejected by the learned trial court below. Lordship, the basic facts of the case were that in this case, though a supplementary charge sheet was filed, however, till the date, that is the 90th day of our remand, no final charge sheet was filed. As a result, we filed a petition for being enlarged on the ground of default bail. However, Your Lordship, if I may take you to the impugned order, Your Lordships, the impugned order starts at page 14. The relevant portion, however, Your Lordship would find at page number.
Have you seen yesterday's news? This Rita Sabria
Yes, Your Lordship.
is
Ritu Chabria.
kept on hold
Yes, Your Lordship.
by this, by 3 judges bench
Yes, Your Lordship.
in Manuar,
Manpreet Singh.
Manpreet Singh. Then yesterday, Honorable CJI has said, we are deciding the issue very shortly.
Yes.
And that by Manuar, Rita Sabria has been kept on hold.
Yes, Your Lordship.
And 3 judges bench said, without being influenced by Rita Chabria.
Yes, sir.
It would require some examination.
Yes.
Immediately
Yes.
heard Mr.
M. Shah.
M.
Shah.
Shah, Learned Counsel for the petition. Mr. Vishwas, you are assisting him?
Yes, yes.
Okay. Okay. MP Goswami. Respondent number 1, State of Assam. First of, this criminal revision petition is preferred. Assailing an order dated 8/2/2025, passed in special within bracket POCSO case number 105/2025. Full stop. Mr. Shah, the counsel for the petitioner, has contended that despite submission of a part charge sheet within the stipulated period, the Planet Court has rejected the application of the, how many petitioners
Don't.
on default bail, despite expiry of 90 days period. First up, matter would require consideration, issue notice, returnable on immediately vacation to the Diokata date. We'll, no, 27th. We'll see it on a hearing date, 27th.
Obliged.
January 2026. I don't think only this order is to be analyzed.
Yes, Your Lordship.
Nothing more. Everything is admitted there.
Admitted, man. And within 60 days, the
Part charge sheet.
yes, search sheet filed.
Whether it
because
is part charge sheet will comply.
That will be depend upon the order of the magistrate.
By that
and-
time, the larger bench decision may come.
Yes,
Yes, Your Lord.
enlightened.
I was reading, I did not know. I was first
Yes.
news that CGI is saying that we are deciding it very shortly.
Yes.
So then I read the news.
Right.
Then
This case is pending long. It has been challenged, madam,
2 years back.
2 years back.
Huh?
Now, the honorable CA.
Yesterday only say.
Yes.
Yesterday he said.
Yes, that observation is made earlier, man, that without
Without being influenced by,
influencing, yes.
by that is by 3 judge bench led by Honorable Dr. Justice Chandrachud.
Lord.
Okay, next.
Obliged.
Item
Nice.
21.
It's settled, my lord. It is very nice, man.
Yes, Mr. Hazarika.
Made, please, your lordship. My lord, proceeding is at the stage of charge has been framed at the stage of evidence. And now,
It would require.
my lord, just two.
It was listed yesterday, right?
Yes,
man.
Then I did.
Yeah.
Not very satisfied.
Yes,
I
ma'am.
don't did.
Page 33.
My lord, page 30 is the FIR. Just, my lord, here.
I read entirely.
Yes, my lord. My contention is on two folds, my lord. I am the registered owner of the vehicle, my lord, in question. I have been paying the EMIs, my lord. The opposite party is my sister, cousin sister. Some
This
areas-
is 406, right?
Yeah, only
406.
only 406, my lord. My lord,
There is privacy elements of 406.
406, my lord, here.
Cannot be outrightly
No,
discarded.
my lord,
We have to go by the contents of the
Yes.
complaint and the charge sheet.
And the search sheet, my lord.
my lord, here, otherwise there is a money suit also filed. That is there, my lord.
Parallel can be.
Yes. My lord, here only my submission is this, from the FIR it can be transferred, my lord. The C is what actually happened, my lord. I'm not going opening mouth as a defense, my lord. From the FIR I'm saying, my lord. The hard contention is that there are some EMIs are yet to be paid. She want me to pay everything and to make the car in her name. This here, my lord.
But as per the statement, she transferred the money to your account.
Yes.
My lord,
It is not that handing over cash.
Yes.
Yes. My lord,
Yes.
but here, my
It is
lord.
not that handing over case, yes, it can be said that, yes, may be true, may not be true.
Yes.
But so far as transfer of money to your account,
Yes.
that is, that cannot be
No, sir.
outrightly discarded.
Discarded.
My lord, here I just want, I don't take much time, just 1 minute, my lord. My lord, this particular money is against the returns on the car. Immediately after I bought the car, my lord, as a cousin sister, she used to be in my house. These are all matter of fact, still, my lord.
Vehicle was used by her
Her, that is against that, my lord,
in a different place.
in a different place. And there was an understanding since she's keeping the vehicle.
Better to sort out the issue between cousins
Yes,
before
yes,
taking,
my-
before
my lord,
taking
that
the
is right.
issue, litigation further.
Yes, well.
It is up to you.
Yes, yes, my lord,
You
therefore,
should
my
appeal at
lord,
this stage.
This, my lord, on 22nd is the 22nd, my lord, is the first date of evidence. Once the actual things, my lord, can it be this way, my lord, till the returning date? Because on next 22, my lord, is the evidence. That is
Your
where
bail was granted only because period of detention,
Yes.
yes,
Page,
not on ground of
no,
merit.
no,
paragraph
At the
7, my lord.
investigation stage.
yes,
Yes.
Even that court has tentative view
you,
that
there are
materials were there.
there are materials.
Lordship, paragraph 7, my
And
lord.
plus charge sheet also, and it is not that
Only one paragraph was there, my
this
lord.
requires this requires an analysis.
Lordship.
It is not that a simple case that from the FIR itself,
Yes,
privacy view can be formed.
yes.
Will issue notice.
My lord,
When is your date?
Another
When is your date?
22nd, this 22nd.
December. We can't help it.
My lord, can it be this way, my lord? I have earlier, 22nd, my lord, will find an adjournment on this ground, my lord.
It is up to you.
My lord,
We will issue notice, so
can
court
it
is
be
looking.
observed that way, my lord?
We'll
Because-
say that matter would require consideration.
Yes,
That much.
because 22nd, if my lord, witness turns up, my lord, we have to again cross, because that will again.
We have to respect the parameters of
Yes. True, my lord, true.
parameters laid down consistently. We have to look into that also. We
Yes.
cannot just go on giving
I got it.
relief, interim relief. Let
My
us
lord, prima facie, my lord, only my.
I think these are there already statements. If you have received the copies of the statement
Yes.
annexed, you have annexed the statements.
No. Copy.
If you have entered appearance
Yes,
and received
lord.
207 copies,
yes,
make it a part
yes.
by an additional affidavit.
Perhaps he has not appeared.
No, appeared.
Yes.
Charge has been framed.
Charge has been framed, he said.
Sir, accused is
At that,
absent.
no.
No, he
thereafter.
said
Yeah.
he has
There.
entered appearance.
Yes, there.
Definitely that is after the stage of 207 perhaps.
Yes,
Yes.
definitely after copy, my lord.
Heard Mr. T.H. Hazarika, learned counsel for the petitioner. And Mr.
Oh, accused present. This one.
Islami.
Remove
That's point number 1.
47.
Uh,
47. PBR1.
Petition has preferred the
Oh.
present criminal petition under 528. 528 or 528? PNSS. Seeking setting aside
24 to
of the proceedings of PRC number 90/2024 within bracket DR case number 1251/2021 as well as the FIR registered as Patharkandi Police Station case number 188/2026 and charge sheet number 197/2023. Later 2023, submitted in connection with Patharkandi Police Station case number 188/2023. First of it is the proceedings of PRC number so and so is presently pending before the Court of Judicial Magistrate, Learned Judicial Magistrate First Class, within bracket Roman 2 Sribhumi. Post of Para Mr. Hazarika, Learned Counsel for the petitioner has submitted that even a primary perusal of the FIR and the charge sheet would not make out a case under section 406 IPC. Post of matter would require consideration. Issue notice returnable. So, Kusami, respond number 1. Respond number 2, steps by speed post within 3 working days. Okay. I already got scan copies of PRC case number so and so.
My lord, yesterday my friend, learned friend pointed out, my lord, inadvertently 482 was mentioned in the.
No, it should.
My lord.
11/2.
Deeply obliged.
11 February.
Yeah, my lord.
Within bracket লিখি দিও 5282 482 CRPC bracket লিখি দিব.
For admission, item 16.
Made, please, your lordship. I'm convicted
main
under-
word. Main list. POXO.
POXO,
We'll
file.
notice.
Yes,
Notice.
How as in the I also.
Yes,
Heard Mr. T. Deuri, Learned Counsel for the accused appellant, and Mr. MP Goswami, Learned Additional Public Prosecutor for the respondent number 1 from our state of Assam to stop the present criminal appeal under section 415 Bharatiya Nagarik Surakha Honita is directed against a judgment and order dated 13/10/2025 by the Court of Learned Special Judge POXO Golaghat Special Court in Special POXO bracket of Richard case number 72/2021 posted up by the judgment and order dated so and so, the accused appellant has been convicted for the offenses under section 448 IPC and section 10 POXO Act. Post for the offense under section 448 IPC, the accused appellant has been sentenced to undergo simple imprisonment for 1 year and to pay a fine of ₹1,000, with default stipulation. Full stop. For the offense under section 10 POXO Act, the accused appellant has been sentenced to undergo rigorous imprisonment for 5 years.
Yes, your lord.
And to pay a fine of ₹10,000 with default stipulation. I have gone through the grounds urged in the memo of appeal. The appeal is admitted for, the criminal appeal is admitted for hearing. Let the TCR be called for. Issue notice returnable on so and so. As Mr. Goswami, respond number 1. The steps upon the respond number 2. As per the notification dated so and so, the Learned Additional Public Prosecutor shall obtain a report as regards service of notice upon the respond number 2 from the jurisdictional officer in charge. Officer in charge of the jurisdictional police station to place the same before the next date of listing. To stop Mr. T. Deuri, I, applicant appellant, MP Goswami, opposite party, just respond number 1, state or Assam, on the instant application under section 430 BNSS is preferred, seeking suspension of execution of the sentence passed against the applicant appellant and for his release on bail. Post stop para. The applicant as the appellant has preferred the accompanying criminal appeal number so and so. Post stop by লিখি দিব. Same.
13/2.
Very grateful.
Item 23.
Mr. Jain.
Yes,
I think I thought it since your leave has been granted, will not reverse the clock. Since leave has been granted already by a coordinate bench, I thought it that
Yes, it is not.
let it be. We'll admit the appeal.
Yes, ma'am. Well, inadvertently, the state was not implicated as a party while filing the appeal. I may be allowed to-
Otherwise, not required.
Not required.
State is otherwise not a party. Heard Mr. B.K. Jain.
Yes, ma'am.
Learned counsel for the appellant. To stop the present criminal appeal under section 419 within bracket 4. BNSS is directed against a judgment dated 13/5/2024 passed by the Court of Judicial Magistrate First Class, Kamrup Metro, Guwahati, Trial Court, in CR case number 1348 for C/2017. Full stop. The special leave to appeal is submitted under section 419 within bracket 5 BNSS has been granted on 15/10/2025. Full stop. Para by the impugned judgment and order dated so and so. The respondent, who was the accused in CR case number so and so, has been acquitted. Full stop. The criminal appeal. I've gone to the grounds urged in the memo of bill. The criminal appeal is admitted for hearing. Let the TCR be called for issue notice returnable on so and so. The appellant shall take steps for service of notice upon the respondent by speed post within 3 working days from today.
Item 24.
Yes, we will do the same. I'll not reverse the clock. Miss
P. Gupta. P. Gupta.
B. Gupta. So Vicky almost. Oh. So Vicky need to silo. Need to silo. Era maribo. Where is the judgment?
Lordship will find judgment in page number 38.
8/4/2016. Baki 419 ebu so Vicky. Judicial Magistrate First Class, Kamrup, Guwahati, Trial Court, CR case number 2468 2010. Leave to appeal. Is granted. On 2/12/2025 in criminal leave petition number 51/2016. Just because 2016, so I am not getting it reversed. It to criminal leave petition to. Okay. Back in this thing.
Much obliged.
Into. Item 25 for orders.
Yes, Mr. Das.
Lordship, matter pertaining to criminal division, Lordship. So
You are the last
Yes, Lordship.
advocate on the last day of 2025,
25. Yes, Lord.
right?
Yes, Lordship.
For me. So I'll remember. So
Yes,
wishing
please.
you all
Me too.
Merry Christmas and Happy New Year. Right.
Thank you, Lord.
Heard Mr. R.C. Das, learned counsel for the petitioner. Revision petitioner and Mr. MP Goswami, learned additional public prosecutor. For the respond number?
Respond number 2, my.
2, Lords.
2.
Respond number 1 is state.
State, Lordship. 2 is up.
No, 1. Respond number
One
1, State of Assam.
State.
Full stop. this is delay.
Yes,
Delay.
Lordship, 49 days, Lordship.
Okay. The instant interlocutory application under section 5 of the Limitation Act 1963 is preferred, seeking contribution of delay of 49 days, comma, which period of delay has occurred in in prefer filing
Yes.
the accompanying criminal revision petition issue notice returnable on so and so, as Mr. Goswami has appeared and accepted notice on behalf of the opposite party number 1, huh? No formal notice, extra copy, 2 working days, 3 working days. Steps upon respondent number 2, opposite party number 2 by registered post within 3 working.
13-2.
After that, we'll call for TCS.
And Lordship, the execution proceeding not to be executed, Lordship, because Lordship kill the return.
Appeal
Not
not
permissible in
listed.
law.
Yes, Lordship.
Appeal is not yet listed.
That order, my order will be illegal.
Must.
We wish your lordships
Yes, happy new year to all.
happy new year.